Hanrahan.
Madam Chief Justice, Justices, may it please the Court, I'm David Hanrahan. I represent the appellant in this case, Attorney Daniel Goldstone. And as you can see from the papers, this is an appeal from what I respectfully submit was an unfair and inappropriate use of the doctrine of collateral estoppel affirmatively in a Board of Bar Overseers disciplinary hearing that resulted in a decision to disbar my client. A brief summary of the facts are these. Mr. Goldstone became a lawyer in 1988. 4 years later, approximately, he formed the firm of Goldstone and Sedalta in contemplation of purchasing the then collection practice of one Eldon B. Sedalta, who had been a collection attorney for many years. He had died, and negotiations were ongoing with the Sedalta widow. During the course of time, before the closing on the purchase, Attorney Goldstone had every opportunity to see how the firm handled the accounting, how the firm handled a record of all of the monies paid out, monies expended on costs, and the like. And the evidence and the facts are that it was reasonably clear from everyone present on the staff, Mr. Sedalta and others, and in particularly a gentleman by the name of Fred Casson, that one need only look at the cover of every one of the files to determine how you find out whether or not costs were reimbursed or anything to do with the file. One of the things that Attorney Goldstone noticed very quickly was that Sears, which had been a major client of the Sedalta firm, had practically stopped sending any new cases. He inquired of a person in the office who informed him that the reason why there was not going to be any more cases is because Eldon Sedalta had not closed cases for years. There was an imbalance in the collection ratio, and unless those cases were closed, he couldn't expect to get any more. That being the case, Mr. Goldstone sought to determine how he could find out what the costs were, and armed with his own personal knowledge from what he observed, and with discussions of the staff, including Mr. Caston, he began the process of closing the files, which involved looking at the cover, having Mr. Caston do all of the work, determining what costs were in fact reimbursed and what were not. And then when Caston got done with that part of the exercise, he handed it over to Attorney Goldstone, who then applied his experience and judgment at that time to see what hourly rate was expended at $60 an hour. This is what he was told to do by the person with whom he spoke in the Sears office that administered the business between collection firms and Sears. Several bills were sent over a period of a few months, and they were not paid. And so what Mr. Goldstone did, and I believe it was something important to have done at the time, is he then wrote directly to the counsel's office at Sears. So now he's no longer relying on a person who is working in an office, referred to as a low-level employee, but nevertheless the employee with whom people like Mr. Goldstone discuss things. He wrote a letter which is very crucial in this case. It's dated May 28th, 1992. It's at page 72 in the appendix. And what an attorney, Emma Scott, said to him at that time is crucial, I believe, in what colored Attorney Goldstone's mind and affected what he did from then on. He writes to her on May 28th and says, "Please allow this letter to confirm that you have assured me that payment of the outstanding invoices received by Sears Boston Credit Central over the past several weeks," I'm going to skip a little bit, "furthermore, Sears acknowledges the assignment to Goldstone and Sedalta of the contract executed by Eldon B. Sedalta, and accordingly all cases received by Eldon B. Sedalta, P.C., and/or Goldstone and Sedalta, P.C., prior to January 1, 1992, will be handled according to the terms and conditions of the aforementioned 1987 contract with Eldon B. Sedalta, P.C. Specifically with regard to pre-1992 closed cases, Sears will be responsible for costs expended and attorney's fees at the rate of $60 per hour in accordance with Exhibit B annexed to the 1987 contract. That document is signed Emma Scott, Esquire, one of the attorneys. The process continued with Eldon, with Fred Caston doing the check on the covers.
I'm very confused, though.
I'm sorry, Your Honor. I didn't
Was that no, I know this in your brief, but I thought the 1987 contract provided for a 45% contingency fee in which costs were not to be separately billed or paid.
That's a different issue, and I'll get to that later when I discuss that portion of it. What we're dealing with here is what was the Goldstone Sedalta firm entitled to on the closing of cases, and that dealt with a different issue. Keep in mind, there were thousands of cases that Eldon Sedalta had never closed. So when we look at that issue, the issue is,
well, did the 1987 contract deal with the closing of cases as compared to the collection of monies under cases?
There was an addendum to the 1987 contract which said in substance that upon withdrawal of cases, Sears would pay costs and $60 an hour. And what has...
The withdrawal does not equate to closing cases, does it?
But here's the problem. There's a latent ambiguity to that language. And I submit that on the facts that we know, when he was told, this is what you do, and then checked it with counsel, and Emma Scott says, listen, in the closing process, keep in mind, thousands of these cases, some of which may still have, by some miracle, had collection, the closing in that context, so that Mr. Goldstone would then be able to get new cases, I believe, was very closely akin to the language of withdrawal by Sears. Sears was saying, look, you're getting no more cases unless you start closing them.
So he closed cases, and by closing cases, he estimated the amount of time Sedalta would have spent on the cases. And he went Sears at the rate of $60 an hour.
Looking at it in terms of what was accomplished, a complaint filed, and in his affidavit...
But you have a contingent fee agreement that provides for a percentage of the amount collected plus $60 an hour?
No. When I get to that, I'll explain that as carefully as I can. Going forward, the contract did call for the 45%. We're talking about all of the old files that Sedalta never, ever closed. And with respect to those...
Mr. Hanlon, first of all, this doesn't help me with the issue preclusion question, which I think, you know,
I was going to get to that in a few moments.
But I take it that what you are saying is that your client closed the cases and billed Sears the amount of time that he estimated had been spent?
That is correct.
Even though Sears had no money had been collected?
Oh, no. Every one of these files had on the covers of them the money that had been collected and sent to Sears, the money that had been expended by Sedalta firm in costs that had not been reimbursed. So that some of these, many of them were actually... I'm sorry.
And was there a contingency fee agreement in place?
But the contingency fee agreement was an agreement between Sedalta and Sears that had nothing whatsoever to do with the closing aspect. And this is crucial.
Of those cases where there had been some collections, Sedalta had already taken 45%.
Presumably he had, when that, keep in mind, many of these were in a prior, many of the pre-1987 cases were at a different rate of 33 1/3%. So that thousands of...
He had taken something, whatever the rate was.
He had taken whatever the rate was, but he had never closed the cases. And so in order for Mr. Goldstone and his new firm to get any new cases, he was put in the position of having to close those.
You can close those, but you don't have to double bill Sears.
Well, you see, Your Honor, you just said double billed. There has never been a shred of evidence that Sears was double billed ever in this case. And let me get right to the issue of preclusion, because I think that's going to be important. One thing I want to suggest to this Court is, if you look at the record, it's manifestly clear that when the case was adjudicated in the federal court, it was on cross motions for summary judgment. Sears had said initially petition for declaratory judgment. Only later did Sears add double billing, and never proved by any evidence that there was such double billing. In the course of the adjudication of the summary judgment motion, a decision was made by Judge Stearns to take the affidavit of Fred Casson, which was crucial to the defense of Mr. Goldstone,
What aspect?
and strike it.
What aspect of the defense was it crucial to?
It was crucial to the issue, what knowledge did Attorney Goldstone have to make it reasonable for him?
No, it's not
to believe?
reasonable. I mean, it's not a question of whether it's reasonable. The question is, do you double bill? Or don't you?
No, let me read what the issue was that the Circuit Court of Appeals said, and I think that'll help clear it up. They said the question is whether a lawyer without personal knowledge that a bill is owed has produced sufficient admissible evidence to survive summary judgment that the obligation in fact exists. They weren't talking about double billing. They put the negative on Attorney Goldstone. Once Judge Stearns kicked out that affidavit of Fred Casson, there was the evidence that was sufficient and admissible to show that the obligation did exist.
What was the evidence? What was the evidence in Casson's affidavit that he had communicated this information to Goldstone? Was there any affidavit that said that?
You have to look at both the affidavit of Fred Casson and the affidavit of Goldstone. Those read together fairly by a judge or a tribunal looking at summary judgment would glean that it was manifestly clear that Goldstone was relying on everybody, including Casson. And Casson's affidavit said, "One will look no further at anything else other than the cover." Mrs. Sudolta testified to that. Mrs. Richmond, who testified on behalf of the Board
But
of Bar
Mr.
Officers, and I'll get to that in a minute.
Forgive me, what you seem to be overlooking is there any evidence to suggest that you looked at the cover, but you didn't look to see whether or not Sears had been billed? Because one of the things that is so startling is you're looking at the cover, you're looking at the numbers of hours, but you're in a contingency fee agreement. So it may well be, for example, that internal to a law firm, you want to keep track of how much time you're spending on this. It may, based on that, you may want to renegotiate from 33 to 45%. But as I take it, your client just went through a whole lot of old files without making any determination whether there had been any billing.
That's not, if I may respectfully say, Your Honor, unfortunately, that is not so. If you look at Casson's affidavit and you look at, combine the affidavit of Mr. Goldstone, what's manifestly clear is that the system, and this was corroborated by Mrs. Sudolta, who had worked all her life with her husband, that everything, all the money that Sears paid, all the money that was reimbursed for cost, everything was on the cover, so that if there was a bill that was paid by Sears, it was dutifully put on the cover. And one of the most striking things is, in all the discovery that Attorney Taylor had representing Sears and Roebuck, they only came up out of thousands and thousands of files, of 4 files, 3 or 4 files suggesting that approximately $131 may have been paid on all of that massive stuff. Let me get to the issue because...
Let me ask you one question. Were you prevented from calling Sears employees as witnesses at your hearing?
Absolutely. There was an order that I appealed from right to a single justice initially on a petition for declaratory judgment. And the justice said that it was premature and sent me back. The order of the BBO was that the issue was strictly limited to the state of mind of Attorney Goldstone, and that's a very restrictive issue, and a very small issue on the subject of commingling, which we deal with in the brief. And also, I want to suggest to the Court in page 51 in the appendix, our argument is more fully addressed there, page 51 of the appendix on this commingling issue. But here's the evil I perceive as to what happened to Mr. Goldstone. And it's particularly important because we're talking about loss of license. A summary judgment in which he was given a burden of proof and a key piece of evidence stricken. The Board of Bar Overseers has an obligation. They have the burden of proof. They will then have to prove that there was double billing because they're alleging fraud here. They're alleging serious misconduct on Goldstone's part, and if I had an opportunity in that context with the Board of Bar Overseers having the burden of proof, I respectfully submit I have a darn good chance of winning that case because there isn't a scintilla of evidence of double billing. Never has been. One of the other difficulties is the procedures, the criteria, by the way, is ultimate fairness. And if you look at what happened to Attorney Goldstone, he never got issues tried. The only essential issue in the motion for summary judgment was that, as the circuit court said, on the record before us, very careful to say that, there's no evidence that he knew that there hadn't been double billing, that he didn't know that.
Can I ask you one further question? Because it goes, and I know you were going to get to this, but you're out of time, but let me ask it anyway.
It goes awfully quickly.
I know it does. This goes to the ongoing work that your client was doing for Sears under the 1987 45% contingency agreement. There is some allegation, indeed one of the charges is that he was, I think the word used is skimming, but in any event, was withholding his costs and still getting 45%, when in fact he should have been reimbursed only 45%, and therefore in essence was collecting twice.
To answer that fully, I'd like the court to consider what goes on in a collection office with hundreds and hundreds of cases all being handled at once, and with communications between the office and Sears Roebuck in this particular case. The testimony was that he had set up a computer program, he had bought a program, which permitted him to gross remit, that means everything to Sears, and then there would be identified any portion of it that could be or should be devoted to reimbursement on costs.
But I thought under the 45% reimbursement, there was no cost reimbursement from
But you
Sears.
still have to keep track of the costs on a gross remit, so that at the end of the line, Sears would know when they're fully paid and the costs are now going to be collected.
Did Sears get 55% of the gross amount remitted in every case?
What they got, Your Honor, was initially gross reports, everything, and then there was a check sent back, a couple of checks sent back to Attorney Goldstone with stickies on them saying, we can't do it this way. Just send us the amount of money with respect to the payment on the debt. We don't want to start to have to do double bookkeeping. He did again what they asked him to do. There's a notation in the circuit court that there was an admission to this, and there really wasn't, because what he said was, I did, despite the contract, I did exactly what Sears told me to do. That's what he did. And one of the things I want to point out is this all took place between 1992 and 1996. The circuit court decision was 1997. 5 years later, he gets hit with the disbarment procedure and the double whammy of collateral estoppel. And I submit to you, when you review the standards that this court has set as to when it's appropriate, I think you'll agree with me, Mr. Goldstone did not get fairly treated by either the district court, the circuit court, I can't say was unfair, but because they said on this record and made it very clear that...
Mr. Hanrahan, the
I'm
red
sorry,
light
we're
is
done.
flashing.
But I submit to you, if you take a good look at the brief and the appendix, you'll agree with me that the motto that's on the wall out there saying everyone's entitled to a fair trial didn't happen here in this case. Thank you, Your Honor.
Thank you, Mr. Hanrahan. Ms. Anderson?
Good morning. May it please the Court. I'm Dorothy Anderson, Assistant Bar Counsel. Mr. Goldstone has had not only one fair opportunity to present his defenses to the charges, he's had two. He had a full proceeding before the district court, the federal district court.
Well, he had a summary judgment.
He had
that
a
was decided on the basis of summary judgment, correct?
That's right, Your Honor. And under the summary judgment standard, as you know, the burden on Mr. Goldstone was only to present evidence that created a disputed fact. All he had to do was to come up with something. And generally speaking, the easiest way to do that is in one's own affidavit to suggest that he had a good faith, reasonable basis for believing that Sears owed him $1.1 million in unreimbursed costs and attorney's fees on these old files that he found in Mr. Sudalter's office. And he did, in fact, submit a very lengthy affidavit, and that affidavit is in the record. And all he was able to say is that on the basis of his own experience, that the general business practices of Mr. Sudalter had been to record all this information on the file covers. He never said in his affidavit that he relied on anyone else, neither Mr. Casson, Mrs. Sudalter, or Sears.
Well, I mean, but I mean, at the end of the day, this is all about fairness. And indeed, such an affidavit was submitted. It was stricken because it didn't comply with the rules, but it sort of went to the heart of the issue, didn't it?
I was referring to Mr. Goldstone's affidavit. Your
Yeah, I
Honor,
mean, Mr. Casson's affidavit
Okay, well,
came
Mr.
in,
Goldstone's
however.
affidavit, which I was referring to, was not stricken. That was part of
No,
the
I
record.
understand that,
Okay.
but an affidavit, he says he was relying on his understanding of the business practices. Well, clearly he got that from somewhere.
But I suppose that Judge Stearns, even though he discounted that because it didn't comply with Rule 26, goes on to say, nevertheless, this doesn't deal with Mrs. Sudalter's
Right.
claim that all of these files were closed. In other words, there were no further amounts due from Sears, correct?
That's correct, Your Honor. Mr. Casson doesn't say he told that he gave this information to Mr. Goldstone. Mr. Goldstone doesn't say he got it from Mr. Casson. And beyond that, the question is, Mr. Goldstone talks a lot about the fact that Sears told him that he had to close files. Well, how do you close files that are already closed? I mean, certainly the implication of closing files would be that those files are open, and yet that there was no evidence or information. In fact, there was plenty of contrary information that those 15,000 files were not open.
I take it, Judge, what seems to be of at least some concern to Judge Stearns was that this was not a mere arm's-length business relationship, but this was an attorney representing his client. And is this correct as a matter of law, that the attorney should make sure that, in fact, the amounts are owed before he submits a further bill, which might be a further bill, double billing to his client?
Yes, Your Honor, there certainly is law, including the case of Salem Realty versus Matera, that says that an attorney always has a fiduciary duty to his client with respect to bills to make sure that those bills are fair and accurate. Clearly, the lawyer depends, the client trusts the lawyer. That's what our system is all about, that the client should be able to have a certain amount of confidence and faith in his attorney.
So there were 15,000 closed files, more or less?
The evidence is that Mr. Goldstone billed on 15,000 files that had been in the office when he took it over from Mr. Sudalter.
Going back for how many years?
I don't think that's a matter of record, but some of them were very, very old. I think some of the ones that you see as part of the record dated back to even the 1970s.
But how many of those were closed? Is there any evidence on that?
Your Honor, closed was not a term within the contract between Mr. Sudalter or Mr. Goldstone and Sears.
Okay.
It doesn't appear anywhere.
But I thought the problem, I know it doesn't appear anywhere, but when Mr. Goldstone calls Sears and says, why am I not getting any more referrals, they tell him he hasn't closed enough files.
That's true, and it's
So it doesn't come from him, it comes from Sears. So what do you mean? You've got to bill us for all of the unremitted costs and fee. I mean, they explain what he has to do. I'm just having trouble understanding why this is, he buys a business. Turns out the business has a lot of accounts receivable that haven't been collected, that he had no knowledge of. He calls the customer. Customer says, well, you've got to close these, and here's what you have to do. I mean, what's the problem there?
well, the problem is, it seems to me there'd be three pieces of information he would have to have before he could do that. First, he'd have to determine that those particular files were actually open. Sears may say, you've got to close some files, but Sears doesn't know exactly what's in his office. And
Why doesn't Sears know that? Sears referred every one of those cases to him. What do you mean Sears doesn't know what's sent to him?
There's no evidence that the woman who had that conversation with Mr. Goldstone had any specific knowledge of what Sudalter's office looked like at that point. Mr. Goldstone...
Why is that relevant? I mean, I'm just trying to figure out why that's relevant.
Well, Mr. Goldstone, before he sends bills, has to know that those files are open, that there's something to close. And if you look at...
What he has, forgive me, what he has to know is that money has been collected from a debtor and sent to Sears that entitles him then to make a claim for fees, correct?
Well, that certainly is the basis of the contract, Your Honor.
But of course it is, so that if in fact the money has been sent to Sears and he has withheld 33%, 45%. He may not have claimed costs. I don't know.
Right.
But as far as I can understand, what he was doing was saying, this file is not closed. I can look at the cover, multiply by 60, add my costs, and I don't know whether or not I've collected a dime. Correct?
Yes, that's exactly right.
And he doesn't know whether or not the 45% has been withheld.
He doesn't know, and he doesn't take any steps to find out.
And we have an affidavit or testimony, is what Judge Stearns calls it, from the deceased's wife saying those were in fact closed files. And what she means by that, I take it, is money was collected and sent to Sears, and you know, her husband had been paid.
That's right. She had, whether those cases were under the old contract or the new contract, the system that she described was that any money collected was put into an account for Sears, was paid to Sears at the end of the month.
Stated differently, and this is where the fact that this is not just purchasing a business, this is a lawyer, and the lawyer comes in saying, looking at the badly maintained files of the lawyer from whom I have bought this business, I can just go ahead and bill Sears. I'm making no attempt to understand whether or not Sears, I've collected any money. I'm making no attempt to understand whether, in fact, 9 hours has been expended. All I'm doing is looking at the top sheet, and on the basis of this, I am sending an invoice to Sears and letting them tell me why I shouldn't get the money and the costs. Am I correct?
That's correct, Your Honor.
And when Sears says this seems out of whack, he comes up with 6 files. We don't know which 6. And they say, well, the bookkeeping seems to be right. So he continues, and at a certain point, Sears says no. Sears then a litigation commences, right?
Right.
And going through however one looks at summary judgment and affidavits and Rule 26 and so on and so forth, there's a determination made that these amounts are not due to him, correct?
There's a determination made, certainly, that there was no basis to believe that they were due, that there was no evidence, that all the assumptions were that, based on the system that had been in place, that all those files had been paid.
So the long and short of this, the proceedings in the federal court determined, as matter of law, that he fraudulently billed Sears.
Yes.
Well, was there that he fraudulently, or that there was no basis for him to believe
that he baselessly billed them, and that he misrepresented that he had a good faith basis for believing that they were due.
So that sounds like fraud to me. And that becomes issue preclusion in the state proceedings to disbarring.
Correct, Your Honor.
And what, if anything, is wrong with that?
I don't think there is anything wrong with that.
Well, that's what I expected you to say.
But you actually didn't seek, you didn't seek issue preclusion with respect to the conclusions of law. You just sought issue preclusion with respect to the findings of fact. Is that right?
That's correct, because clearly it was up to the Board of Bar Overseers to determine whether or not, on the basis of those facts, Mr. Goldstone had violated the disciplinary rules charged. We were not charging him with violating 93A or even breaching his contract. We were charging him with engaging in conduct involving deceit and misrepresentation.
Was there anything in any of those 15,000 files to indicate that Sears had withdrawn the file as opposed to whether the file was closed?
There's no indication anywhere in the record that Sears ever withdrew any file.
In his withdrawal, the question that permits, or the fact that permits him to bill at $60 per hour.
Yes, Your Honor. What the contract says is if Sears terminates the contract, in other words, if Sears
I don't want you to collect on this file
by
anymore.
its own action, right, terminates the contract or says we don't want you to collect on that file, that then the collection attorney would get some compensation despite the fact that no money has been collected. That was clearly the intent of the contract.
Can I ask you what the evidence was with respect to this skimming allegation, please?
Yes. The evidence was that Mr. Goldstone said, I decided that I would I'm collecting for Sears at 45%, and costs are not reimbursed by Sears under the contract, but I tried to send them information which included the costs, and Sears said to me, our computer system isn't equipped to deal with information about costs, from which he concluded that he should take his costs off the top and not report that money to Sears. Clearly, there was no reason to believe that at all. Sears...
So he got his cost plus 45%, and how much money are we talking about?
There's no evidence in the record as to how much exactly that came out to.
I take it that the board is satisfied with Judge Lynch's conclusion, which is, this is what the board is relying on. I take it as a, quote, matter of fact, that because this is an attorney, he's an attorney, the evidence the attorney, presented to substantiate the bills he submitted for over 15,000 files consists entirely of his own interpretation of the handwritten markings contained on the outside of the files and his own estimates of the amount of time that the predecessor Sudolta spent on cases stretching back over 15 years. He lacks personal knowledge that Sudolta, the former attorney, had not already billed Sears on these accounts or had determined that they were not to be billed, right?
Yes.
And she puts that obligation, she says, as a matter of law, interpreting our disciplinary rules, that it is the obligation of the attorney to first determine on something other than his interpretation of a file that, in fact, the money is owed.
Well, she's not interpreting disciplinary rules. She's saying as a matter of Massachusetts law, an attorney always has the burden of proving that his or her bills are fair and accurate.
Well, she's certainly citing to our disciplinary
Isn't that in the Salem case?
Yes, Your Honor, in the Salem case.
That's the standard, right?
Right.
And she's saying, I'm not making a determination. In other words, she is dealing, and the board is proceeding on the basis, it is not the responsibility to determine whether, in fact, there was double billing. It is the attorney's responsibility to show that he did something other than look at the front of a file and send in a claim, correct?
Yes, we did not charge Mr. Goldstone with double billing. We charged him with misrepresentation, fraud, deceit, et cetera.
With respect to this skimming issue, is there anything in the evidence that suggests that Sears did not get 55% of the gross receipts? Now, I don't know. I know the burden was shifted to him to show that, but what I heard Mr. Hand saying was that, look, we had some correspondence going back and forth between the respondent and Sears disputing how the arithmetic was going to be performed on that. But I haven't heard anything that said that Sears did not get the money that it was entitled to get.
There was no back and forth about the arithmetic. Sears just said to Mr. Goldstone, when you send us information about your gross receipts, just give us the gross receipts. You don't have to separate out costs, because cost isn't even mentioned in the contract. We're not going to reimburse you for costs. We don't want to know about costs. Just tell us your gross receipts. And what Mr. Goldstone said is, instead of doing that, he took the costs off the top. So if the debtor sent in $100 and he had expended $20 for a filing fee, he took the $20 and sent Sears $80. Thereby, Sears got 55% of $80 instead of 55% of $100.
How do you know that? How do you know that they didn't get 55% of $100?
Only his testimony, Your Honor, that he did not send them the cost, that he withheld his cost.
Goldstone said he didn't send it.
Excuse me?
Goldstone said he didn't send it.
Mr. Goldstone said, I withheld the costs. I took those from the first payment I received from the debtor. Clearly, when the debtor...
And then he kept 45% of the net amount? Is that what his testimony was?
Oh, he then
sent if the debtor sent in $100 and he had expended $20 in costs, he only sent Sears $80.
And they sent him 45%.
Sears sent back 45%.
Okay.
Now, there's two very troubling emails which are in Mr. Goldstone's brief. Sears' internal emails. Were they in evidence at the disciplinary hearing?
Not as separate exhibits.
What does that mean?
They're basically internal, saying, I have reviewed many of these files. These are correct. These bills are correct. That Mrs. Salter never got around to billing us for these things. I mean, they're a little bit troubling, internal documents. I'm just curious as to...
Well, I believe that they are in the record appendix as attachments to some of the prior filings.
Was there a reason why these didn't get in? Were they excluded? Where it was Mr.
No, they certainly weren't excluded.
Were these issues off the table because of the preclusion? order?
You know, Mr. Hanrahan says that he couldn't call Sears witnesses. I mean, clearly that was not the case. I mean, anything Sears had said to Mr. Goldstone would have been extremely useful information about Mr. Goldstone's state of mind. I mean,
Well, these are all internal communications in Sears about his bills. So these are not communications to him.
Right. I have no memory that they were excluded, Your Honor. I honestly do not remember anything about them, other than that they were part of the underlying record.
Did you seek to call Sears witnesses?
No, we didn't.
Ms. Anderson, could you explain the lengthy delay, or the lengthy period of time between the conclusion of the First Circuit's decision, and, as I understand it, the commencement of these proceedings?
No, I cannot, Your Honor. I started in the office in September of 2001.
Were you the first person to handle the file?
No, Your Honor.
Thank you.
Thank you, Ms. Anderson.
Thank
We'll take
you.
a short break.